for that of the President. The President's satisfaction would be the result of his comprehending in his own way the facts and circumstances relevant to the satisfaction that the government of the state cannot be carried on in accordance with the provisions of the Constitution. There may be wide range of situations and sometimes may not be enumerated, nor can there be any satisfactory criteria. But on a conspectus of the facts and circumstances, the President may reach the satisfaction that the government of the state cannot be carried on in accordance with the provisions of the Constitution. Therefore, the subjective satisfaction is not justiciable on any judicially manageable standards. Moreover, the executive decision of the President receives the flavor of the legislative approval. That is something different because that has to go before the House. We are not concerned with this, my lord. I am relying upon this, my lord, to show that multitude of considerations go into the decision making, whether to grant assent, withhold assent, refer it to the President, or resort to the proviso. And one consideration can be to let the situation cool down. Suppose a parliament passes a law, assembly passes a law that except a particular local language, we will not permit use of any other local language. Maybe it is within list 2. And waiting for 1 year may be considered by the governor in his constitutional wisdom to be a wise thing to do. Then kindly come back to my note, my lord. I am not reading any other. My lord, I have relied upon page 720. 10 minutes.
More than 1 hour.
I'm sorry. My apologies, my lord. Your lordships have been very indulgent, my lord. My apologies to my learned friends also, particularly Mr. Sibal.
Oh, we'll have to compensate that time.
I will.
We will have to compensate. Or you will compensate from your rejoinder, then it's okay.
No. But I will compensate outside the court. Not, my lord. I can't compensate the time, my lord.
Just, if I may just have liberty for a moment.
No. Hey, what?
I have signed it from.
That's all. My lord, I have cited AK Call. I am not reading it. Your lordships may kindly read it. But please, my lord, come to page 730. On the lighter side, Lord, for the first hour, Lord, we did not start arguments. First hour was on the preliminary issues raised by them. So nobody needs to be compensated. Now we are being compensated for that 1 hour which we lost. On the lighter side, well, entirely your lordship's discretion, my lord.
4 days was including 1 hour for the preliminary.
Your lordships are right. I am saying on the lighter vein, my lord. Your lordships can, my lord, extend time, curtail time. That's absolutely my lord's discretion. My lord, page 730, my lord, I have cited one British judgment, my lord, which I generally do not cite, but 2 reasons. A, my lord, our writ power is, my lord, prerogative writs as was available in England. And second, our constitution is essentially and broadly framed on the British parliamentary system. My lord, only one paragraph. And, my lord, this judgment is cited in India from beginning, my lord, not in a recent time, my lord. From the beginning, and it is cited with approval of this court, my lord. My lord, kindly see 731. But I do not think that the right of challenge can be unqualified. It must, I think, depend upon the subject matter to the prerogative power which is exercised. Many examples were given during the argument of prerogative powers, which, as at present advised, I do not think could properly be made the subject of judicial review. Prerogative powers such as those relating to making of treaties, the defense of realm, the prerogative of mercy, the grant of honors, dissolution of parliament, and the appointment of ministers, as well as others, are not, I think, susceptible to judicial review because their nature and subject matter is such as not to be amenable to the judicial process. Now, my lord, I have given 4 classes.
But in England, the powers of the High Court are much restricted as compared to the powers of our High Court.
Correct, my lord. Correct. They cannot even go into the question of validity of a law.
Validity of a law.
I am on a limited point. Then there are certain prerogative functions of co-equal constitutional functionaries which would not be subjected to prerogative reads by the judiciary. That is what this judgment says. Your lordships would be guided. That's my respectful submission. By these four factors which I am not reading or elaborating, the authority, which authority the government is exercising under Article 200. What are the nature of its functions? Second is nature of the function. Third is the stage of the process. Your lordships are, as held in the judicial view taken by the division bench, there is a permissible approach to Article 32 or 226 at a stage where the bill is yet to become law. If you come here, that withholding is wrong. Grant of assent is wrong. Even reference to the president is wrong. Reasons are not given. Reasons are unnecessary reasons. That's what the view has taken. That view, your lordships may have to say correct view or a wrong view. Then constitutional choice in Article 200 is not binary. I have said, distinguishing it from Article 356. It's not that whether to appoint president rule or not to. There are several choices and multitude of contingencies to be kept in mind. One judgment, and I'll read only one part. Somebody came here that criminals should not be inducted into the ministry. This honorable court, has said this at page 733. It's a 5-judgment judgment, Manoj Narula. Thus, while interpreting Article 75(1), definitely a disqualification cannot be added. However, it can always be legitimately expected, regard being had to the role of minister in Council of Ministers and keeping in view the sanctity of oath he takes, the Prime Minister, while living up to the trust reposed in him, would consider not choosing a person with criminal antecedents against whom charges have been framed for heinous or serious offences, etc. And last, rest has to be left to the wisdom of the Prime Minister. We say nothing more, nothing less. This applies with equal force to the Honourable President of India and the Governor. Then your lordships may kindly come to Khera versus Shergill, page 734. I'll read only the highlighted part at 734. Immediately after citing New Zealand judgment, the distinctive feature your lordship gets, highlighted part. The distinctive feature of all these cases is that once the forbidden area is identified, the court may not adjudicate on the matters within it, even if it is necessary to do so, in order to decide some other issue which itself unquestionably justiciable. Where the non-justiciable issue inhibits the defense of a claim, this may make it necessary to strike out an otherwise justiciable claim on the ground that it cannot fairly be tried. If it is unjusticiable, even connected justiciable issues would also, the court would be refrained from examining. Your lordships, my lord, the chief got that, my lord?
Yes, sir.
Yes. Lord, Article 361, my lord, this is my last point. Please come to, my lord, page 736, Rameshwar Prasad. My lord, my lords, perhaps, my lord, indicated, had in mind, para 173. Incidentally, my lord, Justice Narasimha appeared, my lord, in the matter. Para 173, my lord. A plain reading, may I read, my lord, page 737, my lord. A plain reading of the aforesaid articles show that there is a complete bar to the impleading and issue of notice to the President or the Governor, inasmuch as they are not answerable to any court for the exercise of performance of their powers and duties. Most of the actions are taken on the aid and advice of Council of Ministers. The personal immunity from answerability provided in Article 361 does not bar the challenge that may be made to their actions. Under law, such actions, including those actions where the challenge may be based on the allegations of malafide, are required to be defended by the Union of India or the state as the case may be. By Union of India means President of India and Governor means state. And we are now examining, your lordships are examining a question whether state can file a petition challenging government's action. Then there will be nobody to defend it. Even in cases where personal malafides are alleged and established, it would not be open to the governments to urge that the same cannot be satisfactorily answered because of the immunity granted. In such an eventuality, it is for the respondent defending the action to satisfy the court, either on the basis of the material on record or even filing the affidavit of the person against whom such allegations of personal malafides are made. Article 361 does not bar filing of an affidavit if one wants to file on his own. I have my reservations, but this is the law declared, my lord, by this court. The bar is only against the power of the court to issue notice or making the president or the governor answerable. In view of the bar, the court cannot issue direction to the president or the governor for even failing to assist, filing affidavit to assist the court. Filing of an affidavit on one's own volition is one thing, then the issue of a direction by the court to file an affidavit. The personal immunity under Article 361(1) is complete, and therefore there is no question of president or the governor being made answerable to the court in respect of even charges of malafides. I am citing this as a judgment. As students of law, we may have our views. And, my lord, kindly see in the final conclusion, my lord, at page, my lord, 738, para 179, the position, your lordship gets one. The position in law, therefore, is that the governor enjoys complete immunity. The governor is not answerable to any court for the exercise and performance of the powers and duties of his office, or for any act done or purporting to be done by him in exercise and performance of those powers and duties. The immunity granted by Article 361 does not, however, take away the power of the court to examine the validity of the action, including on the ground of malafides. But again, this was not in the context of his legislative function under Article 200. In a matter where he cannot be even defended by the state and will not be defended by the state. My lord, in Nabam Rebi, I am not, my lord, reading that judgment, the governor was issued notice. Lord, it was pointed out that 361 is immune. Well, this is a 7-judge bench judgment. The court withdrew the notice issued to the governor. Said, no, it was a mistake. We should not have issued notice to the governor. Lord, kindly come to my lord.
But he appeared on his own and filed an affidavit.
That's what the judgment also said. On his own volition, he can come.
That is, exactly 2 minutes back, I read that. Exactly 2 minutes back. And both of us appeared. We know that happened. This social media and reels have created a problem. I'll proceed further. Please come to 741. And this is my last submission, my lord. Para 41. It is submitted that the judicial pronouncement interpreting Article 361 was in the context of an action of the president or governor not relatable to either Article 111 or Article 200 or 201 of the Constitution. The cases decided by this Honorable Court held that government can answer on behalf of the governor. In practice, the secretary to the governor is joined as a party so as to enable the court to seek the record from the office of the governor to satisfy itself about the existence of material, procedure, etc. But in case of executive functions, here material may be available, but the satisfaction, which can be in the form of grant of assent, which can be in the form of withholding of assent, reference to the assent or reference to the my lord, house. My lord, kindly see the devastating consequence. Suppose the governor refers it back to the house, and if 226 is maintainable, some private citizen will come that why it was referred to the house. My lord, would the honorable court, I'm posing a question to myself, start examining pre-enactment actions of the constitutional functionaries? Which is precisely, my lord, the law which is laid down. My lord, therefore, my lord, my submission is neither 32 is maintainable or 226 at the behest of the state. Number two, even at the behest of private individuals, they are not justiciable questions, and therefore 32 and 226 would not be available, and 311 would also not, I'm sorry, 131 would also not be available, my lord, because it is not Union of India and the state or between two states. My lord, I have cited, my lord, BP single judgment, my lord. Because BP single, my lord, 5-judge bench says that, my lord, I'll just note the para, my lord, they are not agents of the Union of India. That's what, my lord, 5-judge bench has said. 7904,
The Union Government of the
Lord, para 40. I'll just read, my lord. Please note the para, page number 7904, BP single, volume 5.20, page 7904, paras 40. He is not an employee of the Union government.
Page number?
7904.
Volume 5/14.
Yes, my lord.
5.20.
20.
5.20 minutes.
What are the parties' name?
My lord, BP single versus Union of India. Lord, para 40. It says, my lord, he is not an employee of Union of India or agent of the party in power. Lord, para 40, I'll read, my lord, read it fully. It is thus evident, your lordship gets one. I'm sorry, my lord, just a second.
Yes.
It is thus evident that a governor has a dual role. The first is that of a constitutional head of the state, bound by the aid and advice of his council of ministers. The second is a function as a vital link between union government and the state
That's what I
government,
was
which
saying.
my lord the Chief Justice were indicating. He is a link and the state government. In certain special or emergent situations, he may also act as a special representative of the union government. In special my lord, situations, he is required to discharge the functions related to his office, different roles harmoniously, assessing the scope and ambit of each role properly. He is not an employee of the union government, nor the agent of the party in power, nor required to act under the dictates of political parties. There may be occasions when he may have to be impartial or neutral umpire where the views of union government and the state government are in conflict. His peculiar position arises from the fact that the Indian constitution is quasi-federal in character. So, my lord, if governor cannot be joined, governor cannot be made answerable, and it's this issue between union and the state, my lord, I'm putting a question to myself, my lord, who will defend the governor? If the law is right that if he doesn't do it, come to us. If the president doesn't do it, come to us. And they will have to do it in this fashion. My lord, these are my respectful submissions. I'm really grateful for the indulgence. It was an indulgence, my lord, given, my lord, by your lordship so much.
I'll just take a moment, Lord. Our understanding was that this issue was not being addressed, but we have, as state of Andhra Pradesh has filed a 32 Lord. Therefore, I would reserve my right to seek instructions, Lord. If my Lord may permit at the end, I may just respond.
State of Andhra has filed 32.
There are 30, not some other issue, Lord. It's a surplus issue. It's not an issue. Because in para 13,
Better take it special.
para 13, the SG's submission is broad-based. 14 qualifies it, 60 qualified, but 13 is the submission.
I'm saying
is broad-
202, 201.
I'll have to take instructions. I'll have to take instructions on it. That's all. I'm not saying I want to respond to it. I'll have to take instruction on. At the end, I'll just ask your lordship for maybe a few minutes.
It's a proposition of law. I'm not on Telangana, even Madhya Pradesh, Rajasthan, Maharashtra, nobody can file. State of cannot file it, that's all.
You would have to take instructions as to
Certainly.
what is the stand of his case.
Other issues, but we are endorsing and supporting the stand of the AG and the SG. Not this is the only.
Yes, certainly.
You will have seen the timetable, there is, in some states, there are 2 to 3 councils. We have, on this side, we have.
That maybe we have, my lord,
1 minute, yes. We have, when we are saying something, we don't expect,
my
when you object to his,
no, I'm sorry.
in their case, we did not allow more than 1 council per state.
State.
In so far as the other side is concerned, we did not permit more than 1 council to appear for 1 state. So we will have to make a choice.
Lordship will follow the same.
In case of some states, they have given names of 3, 4.
That will still be adjusted. I'll try and work it out in the lunch first. I'll
Yes,
work it out in the lunch.
They will have to choose whoever wants,
I understand.
whoever wants to represent.
Work it out in lunch.
This Bosa will have to sort it out.
Wait, please do, my lords. Well, is my submissions, your lordship will find in volume 2.2. Starting, I am told at 470. Open it here. The actual submissions start from 480. The rest is an index.
Volume 2.2.
Volume 2.2.
Volume 2.2 starts from
Volume Roman 2.2, PDF का page अलग होगा.
PDF. You are telling the PDF page, running page.
No, running page. Running page.
Volume Roman 2.
Well, this is it, the way it looks like. Running page is given by lordship.
Yeah.
Right, will you be here? Will be here.
The link is there, though.
It's on the link also, well, it's of course hard set also. It actually starts at 480.
Yes.
When your lordship starts using it, your lordship may do me the favor of using the second page on the right side rather than the big page. It'll be easier. When your lordship uses it, lordship will use the smaller page. When your lordship uses it, but I mean just for convenience. Let me, well, let's tell lordships in 2 minutes the structure and the sequence. The 3 bigger issues I'll be dealing with. The first, which starts with page 480, that is page 1, is about the whole concept of discretion, the lack of it, the degree of it, etc. in 200, Article 200. So that's the broad discretion point. That is, I think up to pages 61 to up to 63, the smaller page 63 of my submissions. It deals with questions 1 and 2. So discretion is a lordship's presidential reference questions 1 and 2. I will then deal, Malus, with questions 3, 4, 6 and 9 collectively, which is broadly judicial review, oblique justiciability, oblique supremacy of judiciary, etc., etc. That will run from 63 to 103. And all are Malus quotations really, because rather than take a lordship to the judgment, the relevant lines are underlined and quoted, as Mr. Mehta has done. The third broad issue, Malus, I'll deal with is the timelines, which will be from page 104 onwards in detail. And then, Malus, I'll deal very briefly with the relatively more subsidiary issues, which is question 8, 10, 11, 13 and 12. That's clubbed together towards the end of the submissions. What I have done, Malus, in structure is that on each head, for example, I'm starting with discretion. I've summarized everything I want to say on that in 2 pages in the beginning to give your lordship the sequiturs and the consequences. And the rest is an elaboration of that broadly in the same sequence. So, Lawa Malus, if your lordship will turn to 200, which is at page 1, which is page 480, the longer page. Lordship will use the smaller page.
Page?
480, my first head starts with discretion and article 200. And in that, in the beginning, I have given in 2 pages all the summary points, 7 points in summary of what I am saying on discretion, just summarizing the propositions. The summary is this. First, I will deal with the fact that the governor and the president, I'm reading para 2 at page 1, are titular heads functioning within a federal parliamentary form of government, bound by their respective state and central council of ministers, with no discretion as to executive decision making, save and except where so explicitly conferred by the Constitution, that too in a few rare cases.
What about 163?
Fully dealt with once. That's fully dealt with. I'll make good that. And in each system, this is the pattern I'll follow in each, and under each also, CAD first, some case law then, and the first principles. That's directly 163, 162 will be dealt with. Now the para 3 and 4 are interlinked in an interesting way. I am going to say, that there is strong material as per para 3, give me a minute to oralize, that in each of the 3 options in Article 200 opening, in each of the 3, the governor is bound by the advice of the ministry. In returning back also, and in referring to the president also. And there is material strongly to suggest that. But I immediately after that put para 4, that without prejudice, in the alternative, I have argued fully on the basis that in option 2 and option 3, he is not bound in the first time. But you also will see the material in the para 3 will show that the intention was even for the Council of Ministers to bind him and guide him when he refers his back, how to refer back, when to refer back, if to refer back, and also to the President. But that is not necessary for me to maintain my argument, because I put para 4 after that. Let me read 3 and 4 now. There is strong material, especially in Shamsher and Nabam, as also in the last at least 3 speeches in the Constituent Assembly, respectively by Dr. Ambedkar, Mr. Krishnamachari, Mr. Brajeshwar Prasad, to conclude that all the 3 options exercised by the governor under 200, namely, first is assent to a bill, withholding assent or reserving the bill, are intended only to facilitate lawmaking by the Council of Ministers, and therefore each of the 3 options subjects the governor to the binding aid and advice of the Council of Ministers. This is expanded in paras, pages 29 to 44. They are the internal pages, the smaller pages. However, without prejudice to the previous paragraph, and apart from and distinct from it, the governor in any event, has only 3 options, and if he chooses not to assent to the bill, he may, even without being bound by the aid and advice of the Council of Ministers, either return the bill to the State Assembly once or refer it to the President when the governor first receives the bill, assuming he has discretion to do that without being bound in those 2 cases. 5th is there is no so-called 4th option of making the bill fail or fall through. I'll be showing a phrase, 2 words are plucked completely out of context, completely. And how this one fall-through theory, or as he calls it, withholding asset simpliciter, negates the whole of 200 and the first proviso, liquidates it. Then para 6. Nor is there any 5th option, so 4th option is not there, nor is there any 5th option of sending the bill for presidential assent after having first exercised the 2nd option of withholding assent, returning it to the State Assembly and receiving it back from the State Assembly under the regime of the first proviso. Actually, and the debates are very interesting on this, whenever they talk of the governor's discretion in other articles, which your lordship knows well, some articles he's given discretion by the constitution, they cite 200 only for the second proviso. The governor has a discretion in Article X, in Article Y, which we all agree, there's no dispute. Some judgments, when they cite those articles, club 200, specifically qua the second proviso, which we all agree also, specifically gives the governor discretion. That too subject to the words qua the High Court, not general.
Subject to?
The words given qua the High Court, second proviso. So that discretion envisaged in the whole of 200 is actually only envisaged limited to 200, second proviso. Only, which has been misread and with great respect is distorted in submitting that he has discretion generally under 200. Now this is the entire summary of my first part. And this runs from up to page 63. All quoted at one place. Let me start with the first part, para 8. The Constitution of India envisages a parliamentary form of government. That I will skip. Para 8.1, while the executive power de facto lies with the Council of Ministers, the executive power is formally expressed to be taken in the name of the governor. Thus, the executive powers are wielded by the Council of Ministers. Then was 8.3. The governor does not have any independent discretion in the discharge of their constitutional functions. This is in consonance with both democracy and federalism, and indeed basic structure, which has been held part of basic structure. Whereas the former president called it friend, philosopher and guide, quoting from Pandit Thakurdas Bhargav. He was quoting he was not saying it himself. My submission is that according to me, the governor shall be a guide, philosopher and friend of the ministry, as well as the people in general, so that he will exercise certain functions, some of which will be in the nature of unwritten conventions, and some will be such as will be expressly referred. He will be a man above party, and he will look at the minister and government from a detached standpoint. He will be able to influence the ministers and members of the legislature in such a manner that the administration runs smoothly. In fact, to say that a person like him is merely a dummy, an automaton, or a dignitary without powers is perfectly wrong. Because previous things have said he has a role. He's not a dummy. It is quite right that so far as our conception of a constitutional governor goes, he will have to accept the advice of his ministers in many matters. There are many other matters in which the advice will neither be available nor will be bound to accept that advice. This is Pandit Thakurdas Bhargav. Now let's come, going back from the beginning. Dr. Ambedkar.
He also recognizes that in some matters he will.
Which are
the
expressly conferred. There's a whole list I've given.
And in some matters he may have his discretion.
Some matters he'll be having a discretion.
We have to read 200 along with 163.
Therefore, when they say that you have discretion, of course he has discretion. In 5 or 6 listed articles, which I'm going to deal with, one of them is 200 only qua the second proviso. There is no discretion prior to that. If you read it against me, as I've given in the alternative argument, he has one discretion that first time he can refer back or first time he can refer to the president, if you call that discretion. In fact, it's very interesting, but it's not told to your lordships. The 35 Act had a discretion in both the opening words of the counterpart of 200 and in the proviso. Then first round, in the debates of the assembly, they removed the word discretion from the opening part. Then again there were fights on the word discretion. Then in the second part they removed the discretion of proviso also. And Dr. Ambedkar comments why. Clear pattern. Idea was to give you discretion only in the second proviso. Therefore, whenever your lordship finds discretion mentioned, 163, 1 and 2 are not blanket provisions. They say they are except in so far as the Constitution says. And the Constitution gives you I've got a list of provisions, take out the list of provisions. One of the list of provisions is 200, but only second proviso. That's the scheme, I want. Now, let us kindly come to Dr. Ambedkar. He calls it purely ornamental. These are not my words, the word ornamental. and the selection of the governor would depend upon the personality, status, character, education, and position. Now, kindly read Dr. Ambedkar. It's been said in the course of the debate, argument against election. Speaking for myself, that was not the argument which influenced me, because I do not accept that even under election, there'd be any kind of rivalry between the Prime Minister and the governor. For the simple reason that the Prime Minister would be elected on the basis of policy, while the governor could not be elected on the basis of policy, because he could have no policy, not having any power. Now, this is when they were debating to elect the governor, not nominate him. So he said, I accept that you elect him, even though there's no rivalry.
Still, he will have no power.
He will have no power. So far as I could visualize, the election of the governor would be on the basis of his personality, even if you are electing him. Look at it, he has no power even as the elected person. Is he the right sort of person by his status, by his character, by his education, by his position in the public to fill in the post of governor? In the case of the Prime Minister, the position would be, is his program suitable, is his program right? There could therefore not be any conflict even if we adopt the principle of election. Dr. Ambedkar is very clear, because to say this when you're talking of election is to have a clear clarity about what a governor is in terms of powers. The other argument is, if we are going to have a governor who is purely ornamental, is it necessary to have such a functionary elected at so much cost and trouble? So from being ornamental, he goes to only nomination. Why spend money on elections? Then Malas, page 5 middle. In my judgment, there is no fundamental distinction between the second alternative and the amendment itself. The second alternative suggested is also a proposal for nomination. It is a variant, Malas, or nomination with some conditions. The only thing is that there are certain qualifications, namely that the president should nominate out of a panel elected by the provincial legislature. But fundamentally, it is a proposal for nomination. In that sense, there is no vital and fundamental difference between the second proposal proposed by the drafting committee and the amendment which has been tabled by Mr. Prasad. Then the boldface lower down. Well, I'm reading the boldface. I'm not trying to avoid anything. I can always read something which missed out by mistake, but it'll save time if I read the boldface subject to some other parts. I want to warn the House that the real issue before the House is really not nomination or election. Because as I said, this functionary is going to be a purely ornamental functionary. How he comes into being, whether by nomination or by some other machinery, is a purely psychological question. What would appeal most to the people, a person nominated or a person in whose nominated the legislature has in some way participated. Beyond that, it seems to me, it has no consequence. Therefore, the thing I want to tell the House is this. The real issue before the House is not nomination or election, but what powers you propose to give to your governor. If the governor is a purely constitutional governor, repeatedly the entire approach is that, Willis. That's why we are called a parliamentary democracy, with no more powers than what we contemplate expressly to give him in the Act. The express power is a proviso of 200, second proviso, and some other provisions. Don't say 28, keep it open here. If the governor is a purely constitutional governor with no more powers than what we contemplate and has no power to interfere with the internal administration of a provincial ministry, I personally do not see any fundamental objection to the principle of nomination. Then I skip the middle para, Mr. Chaudhary, come back to Dr. Ambedkar next para. Well, that power an elected or a nominated governor will have. If he happens to call the wrong person to form a ministry, that's the question Mr. Chaudhary asked. What will happen if he calls the wrong person? He will soon find his cause that he has made a wrong choice. After 3 or 4 lines. That is not the aspect of the question which is material. The aspect of the question which is material is this. Is the governor going to have any power of interference in the working of a ministry which is composed of a majority in the local legislature? If that governor has no power of interference in the internal administration of a ministry which has a majority, then it seems to me that the question whether he is nominated or elected is a wholly immaterial one. Then, 3 lines later, they should bear in mind this question. What are the powers with which the governor is going to be endowed? Ornamental. Nothing except a constitutional status. That power, I submit, is not before us today. We shall take it up at a later stage when we come to the questions of 200 and 188. Well, as 188 is wrongly, well, what happened was 188 ultimately dropped, never came in any reincarnation. It was found similar to 287, which is 356. But 188 and 287 were overlapping. Ultimately, 287 became 356, 188 went away. 175 is the present 200. The House should be careful and watchful of these new sections that will be placed at a later stage. So 200 is yet to come. He says that and ends that part for us. Then next page 8 is Dr. P.K. Sen. Now he confesses that he changed his view. Earlier he had a different view. Now I have a different view is what he says. I must also confess that I am one of those members who have changed their views. What is the change, Malas? Come to the middle of page 8. Since then, on sober and serious reflection, evidently, the members of the House are now persuaded that a general election of that kind, whereby the governor was to be elected by adult suffrage, would impose a tremendous strain upon each province and would hardly subserve the purpose for which it was being held. What is the purpose? The upholding of democratic ideas. The question is whether by interfering, so because democracy itself is the basis when you change him from a non-executive governor to any executive role. Democracy itself is at stake. The question is whether by interfering, the governor would be upholding the democratic idea or subverting it. It would really be a surrender of democracy. We have decided that the governor should be a constitutional head. The premier, well, the note is that it's the chief minister. It used to be called a premier for a long time. With his council of ministers, is really responsible for the good governance of the province. The whole of the executive power is vested in the premier and his council of ministers. That being so, if there is another person who is able to feel that he has got the backing of the whole province behind him, and therefore he can come forward and intervene in the governance of the province, it would really amount to a surrender or subversion of democracy. Well, not in the debate, but somewhere else I read, I'm not able to trace it. The Hindi phrase, ek byan mein do talwar, two swords in one scabbard. That is the antithesis of democratic functioning by an elected chief minister. You should not do anything by implication or interpretation which will make it two swords in one scabbard. It would make it impossible for the premier or his council of ministers to initiate measures which would be in the best interest of the province. Only in exceptional cases of emergency should he have the power or the function to step in. It would make it impossible for the premier or his council of ministers to initiate measures which would be in the best interest of the province. Only in exceptional cases of emergency should he have the power or the function to step in and interfere with the actual governance of the province for a short time. 356 came down the line, that time it was 188, became 287, etc., etc. Of course, the condition and circumstance is such. Therefore, in the best interest of democracy, in the best interest of parliamentary form of government, which has been decided upon the basis of the draft constitution, the election of the governor by adult suffrage is uncalled for and inappropriate. The next method of election that is suggested is election by the legislature. There also there is mischief, only in another form. And a conflict would arise between the premier and his council of ministers on the one hand, and the governor and certain other sections of factions which would be in his support. Therefore, I believe that it would, instead of being in the interest of parliamentary government, be a thorn on the side of the premier and the council of ministers and would prevent them from carrying out any measures which are in the best interests of the province. Then come to the next page, brothers. The function that the governor has to fulfill, as it is now borne in upon the members of the House, is that of a lubricator, if I may use that expression. A facilitator is another word, which he doesn't use. He is not to interfere, but he has to just smooth matters. If there are factions, if the different sections of the community are at loggerheads, it is for him to act more or less as a lubricator, a cementing factor. He is to help the machinery of the government, which is in the hands of the Prime Minister and the Council of Ministers. He is not to come and interfere and cause confusion or chaos. He would be the person really to lubricate the machinery and to see to it that all the wheels are going well by reason not of his interference, but his friendly intervention. And this, I believe, is Mr. Sen, who had a contrary view earlier. He says, I confess, I've changed my view. Then, So we've done with the CAD debates. We are only on the general point.
He now supports the view that he should be appointed by the president
Yes.
on the advice of the area and advice of the central government.
Correct. But on the reasoning that any other alternative will give him a role which he should not have. He's formal, he's constitutional, he's titular. It's in his name that you act. The reasoning is what I have quoted, Wallace. Of course, the debate was elect him like this, elect him like that, nominate him like this, nominate him like that.
Elected directly or elected through by the members of the Legislative Assembly or nominated.
That's so this is my first summary still going on, Wallace, on 200, on the first part, about the meaning of, Wallace, this whole discussion.
Powers of the governor.
Yes, powers of the government. Now, Wallace, we've done with the CAD. Now we come to the case law. First, obviously, Shamsher. Shamsher has held the field for decades, Wallace. It's 7 judges and it's very comprehensive. I'm only quoting those which are relevant to this, on the lines and the thrust of the CAD, of the Constituent Assembly. Under the cabinet system of government, as embodied in our constitution, the governor is the constitutional or formal head of the state. And he exercises all his powers and functions conferred upon him by or under the constitution on the aid and advice of his council of ministers. Now, this is a summary of 163 also, broadly. Save in spheres where the governor is required by or under the constitution to exercise his functions in his discretion. The constitution itself tells you, the text tells you, not some general, omnipresent, omniscient, residual power in the interstices hiding which is inherent in him. No. This court has consistently taken the view that the powers of the president and the powers of the governor are similar to the powers of the crown under the British. It's very interesting, Wallace. They trace it to the crown, where it is, I would say, Wallace, it would be horrifying if the Queen ever decided to, Wallace, do any of the things which we are having sometimes now. But just note on the side, it will come later. In my smaller numbered page 28, I have given in para 13.4 a list of those specific powers of the Constitution. Lots of note on the side only, it's coming.
Page?
At page 28, the smaller page, para 13.4, I have listed Article 167, if the governor so requires, 200 proviso second, 356, 371A, there may be more. I've given an illustrative list only. Schedule so and so. Please come back to para 28. I have my small page 11. Please come back to 11.
Yes.
This court has consistently taken the view that the powers of the president and the powers of the governor are similar to the powers of the crown under the British parliamentary system. And so many cases are cited. Turn the page. Ram Javaya, that famous case, fellows. Then next page. The initiation of legislation, the maintenance of order, the promotion of social and economic welfare, the direction of foreign policy, the carrying on of the general administration of the state are all executive functions. The executive is to act subject to the control of the legislature. The executive power of the union is vested in the president. The president is the formal or constitutional head. The real executive powers are vested in the minister of the cabinet. There is a council of ministers, the prime minister is the head to it. I'm very sorry to say there is a para in Mr. Tushar Mehta's submissions. I'll read that para. Where many of these very things settled by Shamsher years ago, he says the governor may have to hold a bill back because he has to consider these things. And I am assailing that para for another reason. Doomsday scenarios are given. 9 doomsday scenarios which have not happened happily in 75 years of our republic. A state says only Tamilians can enter the state. A state says only local language can be used. Hypothetically, the sky may fall on our heads, bills. My lords have very evocative passages that please don't judge, especially constitutional adjudication, by disaster scenarios. But that para has got 9 examples which are unheard of, unthinkable. And happily, with all the distortions of our democracy in 75 years, have not happened in 75 years here. So they are very imaginary, and the imagination is febrile and fertile. Now let us come back to page 12. the provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate, 239, now this is the example Lordship asking where they are given the power. The governor is given power by the Constitution. To illustrate, Article 239 states that where a governor is appointed administrator of an adjoining union territory, he shall exercise his functions as such administrator independently of his council of ministers. Now, let's just see. This is some share, which is why what is happening is in some paras of other judgments, they quote the same thing as a general 200 without saying second proviso. And then it is used by the government to say that it is general discretion in 200. Some share correctly says that they are talking of the second proviso, where of course there is discretion.
When the governor of Punjab
Yes.
is also an administrator for the city of Chandigarh. So for Chandigarh, he would not be bound by the aid and advice by the Council of Ministers.
And look at our constitutional famous fellows, they foresaw it. Whether then or now in 239. Obviously, it created a ridiculous situation, but my Lord Chief Justice is giving an example. They should not have it, therefore correctly. So they thought of it, they gave it. Now the second part is what interests me. Just come to the second part of the same para. My Lord is on page 12. The Honorable Chief Justice mentioned this. Just come to the lower part of page 12. Again, Article 200 requires the governor to reserve for consideration any bill, which in his opinion, if it became law, would so derogate from the powers of the High Court so as to endanger the position which the High Court is designed to fill in the Constitution. This is the second proviso which has discretion. And I was just pointing out the error when my Lord the Chief Justice gave that example. In many judgments, 200 is mentioned as an example of discretion, but some judgments, few of them, don't add the subsequent words which Shamsher added. And that is used to say your general discretion. This is the discretion which is in 200. 200 is one of those articles where the governor is given discretion. It is part of my list of 167, 239, etc. But only the second proviso. As the Lordship said of Chandigarh, governor can't allow the High Court to be tinkered with like this. So the Lordship thought of it and put it there. Next paragraph, page 13. In making a report under 356, the governor will be justified in exercising his discretion even against the aided advice. Another example, because 356 says so, there's no question of seeking the aided advice of the government, of state government, to dismiss the state government. There is no question. Now see the last part of that page 13, Manus. In all other matters where the governor acts in his discretion, he will act in harmony with his council of ministers. The Constitution does not aim at providing a parallel administration within the state by allowing the governor to go against the advice of the council of ministers. And the previous lines I have not underlined to save time are all saying he must act at the aided advice. They say again and again. Now, Mullahs, I had read para 54 above at page 12. My Lord has noted page 12, Mullahs, para 54 I have quoted of Shamsher. Two paras later, they say the same thing in para 56, but they don't use the suffix of the second proviso. So my learned friend says that what is clarified 2 paras earlier in 56 means you have general discretion in 200. I hope I'm clear, Mullahs. Now come to 56 at page 13. Similarly, 200 indicates another instance where the governor may act irrespective of any advice from the Council of Ministers. In such matters where the governor is to exercise his discretion, he must discharge the duties to the best of his judgment. The governor is required to pursue such courses which are not detrimental to the state. Just a para before that, which is quoted at page 12, they were discussing examples which included a second proviso of 200. This has to be read in that context. It is not an independent source of, otherwise some share for the last 40 years would be read as an independent source of discretion for the governor. Some share your lordship cites for every presidential discretion, every governor discretion. If this para is led literally to mean that 56 is not anchored in or relatable to 54, then Mullahs, he has complete discretion. It can never be. Nobody is rated like this till now. Nobody. Then Mullahs, page 14. For the foregoing reasons, we hold that the precedent of the governor acts on the aid and advice of the Council of Ministers, with the Prime Minister at the head in the case of the Union and the Chief Minister at the head in the case of the states in all matters, which vests in the executive, whether those functions are executive or legislative in character. Neither the President nor the Governor is to exercise the executive functions personally. This is Samsher, 7 judges, 40 years ago. More than 40 years ago. The present appeals concern, ignore that. Now, let's come to Justice Krishna Iyer. Not only for the language, but for a very fundamental concept he raised. He said this cuts at the root of our democracy. If you start recognizing the governor as having discretion, he takes it to democracy level, but it's a basic structure. Please see that. Same page 14. Thus vindicating our democracy instead of surrendering it to a single summit soul. Single summit soul is a governor, whose deification is incompatible with the basics of our political architecture, lest national elections become Dead Sea fruits. Legislative organs become labels full of sound and fury signifying nothing. And the Council of Ministers put in a quandary of responsibility to the House of the people and submission to the personal decision of the head of state. This is not fully strong Krishna language, not difficult to understand, and also is lyrical. A parliamentary style republic like ours could not have conceptualized its self-liquidation by this process. I think it's a very, very pithy sentence, and very effectively put. Some parts of this Krishna sometimes make us want to go to the dictionary or to Mr. Shashi Tharoor. But this is not so. This is the truth, Willis. There are now, I believe, actual classes which my colleague is doing on this. Difficult words thrown to him and he finds a way out.
One of the learned judges in Kerala follows this.
Yes, well, I heard that.
This is Javan Ramjit.
This is simpler Krishna Iyer, J, and very effectively pithy. Next para. We declare the law of this branch of our constitution to be that the President and the Governor, custodians of all executive and other powers under various articles shall, by virtue of these provisions, exercise their formal constitutional powers only upon and in accordance with the advice of their ministers, save in a few well-known exceptional situations. Without being dogmatic or exhaustive, these situations relate to 1, the choice of the Prime Minister. So now your Lordship is spelling out broadly the areas where there has to be discretion. Suppose the House is being dissolved or somewhere the majority is lost, obviously he'll have discretion. You can't be bound, Malus, by those situations. By paramount consideration, you would command a majority. The dismissal of a government which has lost its majority but refuses to quit office. The dissolution of the House for an appeal to the country is necessitous. Although in this area, the head of the state should avoid getting involved in politics and must be advised by his Prime Minister, Chief Minister, who will eventually take the responsibility for the step. We do not examine in detail the constitutional proprieties in these predicaments, except to utter the caution that even here, the action, even here, where he does have discretion, the action must be compelled by the peril to democracy and the appeal to the House of the country must become blatantly obligatory. Now, Malus, is another interesting example of royal assent, where there is the minimal zero discretion. They give that example. We have no doubt that D. Smith's statement regarding royal assent holds good for the President and the Governor in India. Refusal of the royal assent on the ground that the monarch strongly disapproved of a bill, or that it was intensely, mark the word, monarch strongly disapproved of a bill. According to 5 paras of Mr. Mehta's written submissions, he can judge security, friendly relations, need, calm down, cooling period, political considerations, everything he can judge. And 50 years ago, 7 judges said this. 50 years ago. Or that it was intensely controversial would nevertheless be unconstitutional. Refusal of assent, even though it's intensely controversial,
This is 2 judges.
and he disapproved.
What you are reading is 2 judges. Yes,
I stand corrected. This one is there, this is there. Very well. 2 judges held the field for many decades. Perhaps my lords may want to change it. I don't know. Lordships can.
But
Just check up. Let me check up. Is it
a minority view?
is it part of this?
No, it's not.
Concurring. Let me just check up. I want to be sure. What happened was, Billis,
Justice Bhagwati, Justice Ray, Chief Justice Ray was with Justice Bay, Justice Matthew, Justice Chandrachud, Justice Allegance. 5, but both.
so I stand recorrected in my favor. And Mr. Mehta should stand corrected also in his error.
Sentence of Potomac and Thames comes to this.
Yes, Potomac and Thames is here, isn't that? That the waters of Potomac, not the Potomac, but not the Potomac and the Thames, but the Ganges should fertilize. That part is also in this. But Palas, I was just going to check up. This is all part of the concurring. But I'm sorry, just give me a minute. Just turn to, they are taking it that we make it akin to refusal of royal assent. And in royal assent, D. Smith was one book, Wade is the other book. Much before Mullis, in the old days in England, they have said that even if he is intensely controversial and he strongly disapproves, even then, if he withholds assent, it's unconstitutional. I will read the para of Mr. Mehta where he says much more. He actually in that para makes the governor holding the departments of national security, foreign affairs and a few other departments. I will read that para. It's not me. Take out that para first. Don't do this. Yes. Your Lordship may want to note, because we have done the extracts, please note in volume V 5.7, just for your Lordship, was the correction on the interruption by Mr. Mehta. There should be a correction on that. In V.7, 5.7, page 2912, the actual SCC, Krishna Iyer J. and on behalf of himself and Bhagwati J. concurring. My learned friend Mr. Gopal Subramanian is absolutely right. Then they go on, Malus, the concurrence goes on. The only circumstances in which the withholding of the royal assent might be justifiable would be if the government itself were to advise such a course. If you do not try to distort the constitution, everything falls into place. If you want to achieve a preconceived result, then you'll be distorting. A highly improbable contingency, or possible if it was notorious that a bill had been passed in disregard to mandatory procedural requirements. Since the government, the latter situation with the opinion, etc. That's not relevant for us. So this is, well, some share, 7 judges. Now come to Navam Rebia. My learned friend wants me to read what is not quoted by me. My learned friend just wanted me to read one para which is not quoted by me. The very first para of the judgment of Justice Krishna Iyer, where he starts. Lordship will not pick up, just note the reference, volume V7, page 2912. Just I'm reading it, need not take the V7, 2912. These two appeals by a couple of small judicial officers whose probation has been terminated by orders of concerned ministers in conformity with the recommendation of the High Court have projected constitutional issues whose profound import and broad impact, if accepted,
Which para are you reading?
Opening.
I'm sorry, 2912 or V7. 5.7 or V7. Some of the greatest cases are made from very small litigants with small grievances. This is one such case. But the judges pick up the larger import, howsoever small the case is. And Justice Krishna Iyer, with his usual felicity, formulated the issue. Have projected constitutional issues whose profound import and broad impact, if accepted, may shake up or reshape the parliamentary cornerstone of our nation. And it did, Shamsher has reshaped because it stood the ground. Great deference and complete concurrence would have otherwise left us merely to say